excuse me, the House and Senate Conference Committee on Public Safety and Judiciary will come to order. Members, today, just do a quick run through of our agenda. We'll begin with just some opening comments for myself and the Senate Chair. We're going to be hearing from the Department of Human Rights on highlights of their report, right? Yeah. And highlights from the recent findings and report.
House bill provisions.
Okay, so that's the other hearing. All right. On their provisions. Sorry, I didn't mean to freak out the Department of Human Rights here. And then we'll move to Department of Corrections for their highlights. We'll be hearing from Commissioner Schnell. We'll then move over to the conversation on county corrections, a really important conversation. We'll hear from a number of county commissioners. We'll then hear from about county attorney provisions in the bill. We'll hear from several county attorneys, and we'll do questions and answer. Following all that, I like Chair Limmer's approach, where he just had everyone speak, and then we open things up for discussion, and we could have people coming back and forth to the testifiers table. And then with the remaining time, we'll then entertain making some motions here, and the Chair and I will work out how we'll proceed with that. So with that, let me just, I actually didn't spend a whole lot of time thinking about opening remarks, other than to share that we're obviously a week away from being able to finalize this important omnibus bill between the two houses. I hope that as we continue to challenge one another's ideas, that we do so in the spirit of moving toward a final product where we can agree. I still continue to contend that there's plenty for us to agree on, and that should be the appropriate posture, I think, when it comes to public safety and corrections in our courts. So with that, I'll just leave it at that, and I'll ask my colleague, Chair Limmer, to share a few opening comments as well.
Thank you, Mr. Chairman. Good morning, everyone. Looking forward to the testimony today. Over the weekend, the leaders of both respective caucuses or chambers have made their agreed on limitations for the budget. I'm sure many of you probably know what those are, but just for the public's sake, we are to have limits in this area of $200 million for this year and $250 million for the next biennium. Total of $450 million. That is very reflective, almost to the dollar, of what the Senate position originally had. We have not, as of this time, resolved any of those issues of where that money would actually go or what would it be spent on. So we'll be continuing to have discussion. This morning and last night, I received a list of policies that we should consider an invite by the House. It was revised slightly by this morning. We're trying to catch up to it since we got it at 8 o'clock this morning. But we did review some of it last night, the initial phase of it. My concern is, as I said last week, we seem to be nibbling on the small things, and we haven't quite figured out what to do with the gorilla in the room, and that's that budget item. The House came in with a considerably larger bill, money-wise, than the Senate. I think we should be focusing more on that gorilla in the room and get it nailed down. We have smaller policy provisions, and some of them are the ones that are in either both bills or they've been authored by Some are highlighted as somewhat of a priority because they were the first ones talked about last week. Those were DFL bills in the Senate that we accepted. And then there's a whole litany of pages full of House provisions. And this is probably pretty normal when it comes to this type of thing. I'm really hoping that we can begin to really look at the global picture of how our bill is going to be at the end of the day. Putting a few entrees on the plate and not looking at the whole table, I don't think is a good way to approach it. I really would like to see a global presentation of a bill that we could really work on and adjust with more of a 30,000-foot elevation so we can see the whole landscape of the bill rather than nibble at little provisions one at a time. But having said that, I'm looking forward to the testimony, Mr. Chair, and we'll continue the process. I don't know if our members on this side have seen your list that you gave us this morning. So we would like to have a little time to digest that a little later.
Thank you, Mr. Chair, and that I think is certainly appropriate, so we may move to a recess at some point. I'm going to ask our testifiers to stick to the allotted time that we have, because that makes it possible then, or maximizes our opportunity then to focus on that work at hand that the chair just spoke to. So with that, members, we're going to begin with Department of Human Rights, providing highlights of their provisions in the bills, the omnibus bills before us. And with that, we have Commissioner Lucero.
Can I make one housekeeping comment?
Sure. And Commissioner, let me just interrupt quickly. The chair here wants to make a housekeeping.
I was told this morning that at 11 o'clock the Senate will be going into session, and I'm urging our members to stay here until noon. That's our allotted time slot. I think it's wise for us to be here. We can vote remotely if necessary. I think at least our caucus was going to break for a caucus meeting anyway, so I don't think there's going to be any decisions made. So, but other than that, I just wanted to make sure our senators stay here and listen to our testifiers.
Yeah, thank you, Chair. And you remind me that the House is also in session this morning, and we're in a similar situation. We did a caucus last night, and we were encouraged to be here at our conference committees, but you just never know with votes on the floor. That's true of both bodies. But it certainly would be our intention to monitor that from here and then continue to focus on this important work. With that, Commissioner, good morning. Welcome to the committee.
Hi, good morning. Thank you so much for having me today. So good morning, Chair Mariani, Chair Limmer, Chair Becker-Finn, Chair Matthews, and conference committee members. For the record, my name is Rebecca Lucero, and I am the Commissioner for the Minnesota Department of Human Rights. So the Minnesota Department of Human Rights enforces the Minnesota Human Rights Act, which prohibits discrimination. Oh, that's much better. Thank you. Yeah. So now the law powerfully states discrimination threatens the rights and privileges of the inhabitants of this state and menaces the institutions and foundations of democracy, indeed. The law was passed in 1967, and it's one of the strongest civil rights laws in the country. It prohibits discrimination in different areas, such as employment, housing, and education, and on the basis of protected classes, such as religion, disability, and race. The Minnesota Human Rights Act tasks the department with three primary duties. First, investigating charges of discrimination. Second, working with state contractors. Third, educating to reduce discrimination and disparate outcomes. Our budget and policy priorities therefore fall under each of these department duties. So let me start by talking about the first department responsibility to investigate cases of discrimination. Now, if a Minnesotan believes they are discriminated against, then they reach out to speak to an investigator to see if there's jurisdiction under the Minnesota Human Rights Act. If there is, we are statutorily obligated to neutrally investigate to see if there is probable cause whether or not discrimination occurred. Now, one case we recently concluded investigating involved a woman who had a successful career at a dental office. When a new owner took over, however, the new owner did not want to work with that woman because, quote, she is too old. So he terminated her. He said, quote, she is too old to learn new things. In this case, MDHR found probable cause of discrimination based on age. And we worked with the employer to prevent the employer from firing anyone else because of their age and changed their policies and provided training because this is a violation of the Minnesota Human Rights Act to fire someone because of their age. Now, historically, most of our work occurs in employment cases, though we also see a fair amount come in around housing as well. For the areas, each month we tend to see the most cases come in the areas of disability, race, and sexual harassment and assault. Now, investigating discrimination is complex work. It's important to me that when we conduct investigations that we are thorough, comprehensive, and we appropriately apply the law to the facts. It's important that we do this as effectively and efficiently as possible. The investigative team is a dedicated group of public servants, but it is a very small team. And this is why you've heard me year after year continue to request capacity increases for this team. Another example of the importance of this work is 7 cases that we've worked on in the past 6 months around sexual harassment and assault. They exist throughout Minnesota. They occur in businesses and in schools. They happen to women, to a teenager, to a man, all by the hands of people that were in charge. In all of these examples of the employer or in the school, they knew about the situation and they failed to act. In all of these examples, there were not policies in place, or the policies that were in place, they were ineffective and they were not followed. Because of the thoughtful work of the investigators, the cases were investigated and resolved, policies and trainings have occurred, and we hope that, of course, the sexual harassment or assault never occurs again, and if it does, this time with appropriate oversight, it will be addressed immediately and appropriately. So that's why you'll see a specific ask for capacity for investigators in this. Now, these are small dollars in the grand scheme of things, but go a very long way at this agency, so they're a great investment in Minnesota. Now, additionally, when it comes to discrimination, as you know, the work of this conference committee isn't solely focused on budget. There are also critical policy priorities for the committee to consider, and one I would like to highlight is the Crown Act. Now, this has strong bipartisan support. It passed off the Minnesota House in February with a vote of 104 to 26. And so just real broad support for the Crown Act. And it's a critical piece of legislation, and it sends a clear message that denying Black Minnesotans employment or educational opportunities because of their hair texture or hairstyle is race discrimination. When this bill received a hearing in the House Judiciary Committee, Black Minnesotans from across the state testified to their experiences and the prevalence of discrimination they experienced because of their natural hairstyles. The Crown Act provides an important plain language update to the Minnesota Human Rights Act, and it makes it clear that hair discrimination is race discrimination. And I ask that this policy change be included. Now, the second statutory responsibility I noted is to support state contractors on state-funded projects. To do this work, we work with over 3,000 state contractors across the state, and we make sure that men and women are getting paid the same for the same job, and we work to improve workforce participation numbers for workers of color and Indigenous workers. Now, during my tenure, I'm proud of how we've made important steps to transition from an audit-based model to a strategic compliance model. Now, under a strategic compliance model, we focus the resources of the state on specific state contractors that we know need more support or oversight and have the biggest impact. That's why we have 2 requests in this area and one that I'll highlight for you. It's a one-time funding request that allows us to work with a data and technology expert to ensure we are analyzing and utilizing the data we have in the most effective way possible so that we can use that strategic compliance model the right way. So I'd appreciate consideration of this one-time funding request as you put together this, this package here. Now, the last area has to do with the third statutory obligation, and that has to do with education and outreach. And here I'd like to talk about our proposal on bias and hate data, education and outreach around bias and hate. Oh, this is obviously something that's been going on for a long time, and community groups have been involved with and engaged with, but this is something that we spent a lot of time with, especially at the start of the pandemic, when the FBI warned of a likely increase in bias and hate-motivated incidents against Asian and Pacific Islanders in Minnesota. By now, we all know the stories in the news of people harassing Asian Minnesotans for COVID-19, which at times turned violent, sometimes costing people their lives. We saw verbal and physical abuse on the streets, in stores, and at bus stops. Because of these intimidation and harassment, Asian Minnesotans didn't feel safe to just live their lives, to go to those stores, to drop their kids at school. Acts of bias and hate against communities of color are not happening in isolation. We all saw this weekend in Buffalo a self-described anti-Semitic white supremacist who went into a grocery store with the intention of killing as many Black people as possible. At the end of the day, here in Minnesota, we simply do not have the correct data to know what is actually going on in Minnesota. So we don't know how to address it before it gets to this point. The FBI and BCA certainly track crimes, hate crimes specifically, where a criminal act has occurred, where it gets to that point. But there is a lot that occurs before then. Think about a swastika painted on a wall that would not get tracked. So there is no good data that exists for you legislators to understand what the problem is, for you to know how to appropriately address it. This is why we have 2 supplemental budget requests to strengthen the state's ability to address bias and hate. So our first is gathering, analyzing, and reporting data. We need that good data so we can, in turn, make smart public policy decisions. And our data gathering proposal will help us do just that, and it'll help us work directly with community members who are looking for this partnership and support. Additionally, we need more outreach and education around these issues. Our community response team proposal is designed to be able to both respond to incidents of hate and work long-term on prevention. Both of these requests come directly from multiple requests from community groups that are regularly the target of these bias and hate incidents and are just trying to live their lives. At the end of the day, Minnesotans deserve to live a life of dignity and joy free from discrimination. And I know it's important to have the right information to help make that happen so we can do the work on the front end to hopefully prevent these types of horrific tragedies from continuing to occur. So I want to thank you for giving me the opportunity to highlight our department's statutory obligations and legislative priorities, and I am happy to stand for any questions. I do need to run to another meeting this morning, but Eric Armakonki will be here to help supplement if I'm not here later on. But thank you.
Very well, thank you, Commissioner. Eric, of course, is our assistant commissioner, right?
Eric is, yes, he's here to answer any questions.
Right, very well. Thank you, Commissioner, appreciate it. Next, we have Commissioner Snell, Department of Corrections. Good morning, Commissioner.
Good morning, Mr. Chair, Chairman Limmer, and members. Thank you again for the opportunity to provide a perspective from the Department of Corrections in the conference committee. I appreciate very much the opportunity to do that last week. As I said, my name is Paul Schnell. I'm the Commissioner for the Department of Corrections, and I'd like to spend a few minutes explaining the DOC's request. I've mentioned a couple of these briefly, but I'd like to expand on them today. With me today is Captain Chris Mitchell from the Correctional Facility in Faribault, who you'll hear from shortly. I want to start out by just thanking the Senate for including the creation of a reimbursement fund for transportation costs incurred by counties under the Interstate Compact for Adult Supervision. This fund provides reimbursement to sheriffs to transport probation violators who are subject to Interstate Compact. And I urge the committee to adopt this provision, which is important to our sheriffs across the state. The funding for this proposal is on line 209 of the joint spreadsheet and amounts to $250,000 each year ongoing. Members, I just touched on it, mentioned it last week, but as you are very aware, the advantages of body-worn cameras in law enforcement are well documented. There has been an increase of body camera usage in corrections as well, with substantial benefits for staff and facility safety. You'll find the DOC's request on line 208 of your spreadsheet, $1.5 million each year for 3 years to equip our staff with body-worn cameras. As is the case with other DOC requests, this proposal is in response to the 2020 OLA report on safety and security, which highlighted the need for this type of technology. Studies on body-worn cameras for corrections staff have been shown improves safety for staff wearing cameras, not only for assaults, but also to address discipline issues with incarcerated population. But as noted in the OLA's 2020 report on safety in the prison system, the cameras also help to effectively address issues around sexual assault and sexual harassment experienced by many of our female corrections staff, as an issue that profoundly impacts morale, retention, and in many cases is a crime and will ultimately benefit the women and all staff who work in the Department of Corrections. In Minnesota's Olmsted County Jail, a recent implementation of body-worn cameras on jail staff showcases the power of the technology. Olmsted County Chief Deputy Brian Howard, who oversees the jail, was quoted in the media saying, quote, it really did make it safer for our facility, not only for our staff, but for our detainees, end quote. Members, very briefly, I want to reiterate the department's support for equitable funding for community supervision. I can't understate the importance of this funding. The Department of Corrections is a partner in this funding agreement along with Minnesota counties from across our state. And you'll hear from more about this work from county representatives, so I won't go into detail today. However, the House position on line 232 of the spreadsheet, there is funding for, members, I want to briefly talk about the need for us to have a system to address grants and subsidies within the DOC. The Department of Corrections provides critical funding for county supervision, as well as a number of other grants for local contracts totaling $79 million annually. The DOC is requesting $450,000 in fiscal year 23 for a grants management system, which this is noted on line 232 of your spreadsheet, and it is on line 228 of the governor's budget request. We are the only state agency that provides grant without such a systems, and it would be ultimately helpful and critical, we believe, for the management and allocation of the 250 grants that the DOC provides annually. In fiscal year 24 and ongoing, we are requesting funds to be able to ensure effective stewardship of these public funds by increasing our capacity to do this work. And while small, I mentioned last Thursday, the Department of Corrections is requesting $650,000 annually to keep up with rising property insurance costs, which have increased 54% in 2020 alone. And finally, once again, I reiterate our need for public safety data infrastructure requests because it is an issue that touches every aspect of the DOC's work to create better public safety outcomes. And every dime requested of this investment will be critical to helping us carry out our mission. I want to also thank Senator Representative Moeller and Senator Latz for carrying standalone bills for this that include this investment. To summarize briefly, this is a $47 million request over the next 3 years, and it does two things. First, it modernizes the DOC's antiquated system. And as I mentioned last week, many of our systems more than 20 years old. Second, it creates a central hub for information sharing between supervision systems, the Department of Corrections, law enforcement, and the courts. This helps us in the management of nearly 100,000 individuals on supervision in Minnesota at any given time. Instead of hearing about this issue from me, again, I'd like to turn my remaining time over to Captain Mitchell from the DOC's correctional facility.
Very well. Welcome, Captain Mitchell, to the committee.
Good morning, Mr. Chair and committee members. My name is Chris Mitchell, and I'm a captain for the Minnesota Department of Corrections in Faribault. I want to thank all of you for allowing me to speak to you today. I've been involved with the State Correctional Facility Security Audit Group, and I just want to thank all of you for keeping the safety and the security of those who work in corrections on your mind these last few years.
Captain Mitchell, I apologize for the interruption. Can you just pull that mic a little bit closer to you, sir?
Yep.
Thank you.
Is that better?
Yes, thank you.
In particular, I wanted to thank Senator Bigham for her service on that group over the past several months. It has been heartening to see the legislator focus on safety inside of our state correctional facilities. External oversight of our security and other efforts are great steps, and I'm here today to request that you also take a look at the OLA findings about how far behind we are when it comes to our technology. And when it comes to being able to make data-driven decisions on all fronts, security, programming, releases, and more. We're grateful for your investments in corrections over the years, but as the Commissioner has mentioned previously, with a budget that is over 96% reliant on the general fund, we need your help in funding our technology needs. Mr. Chair and members, without a parallel effort to invest in our crumbling technology infrastructure, there can be no serious attempts towards making a prison setting safe in the 21st century. DOC security staff still rely on fax machines to share important information. Our base technology is so outdated, we cannot acquire systems to pinpoint problems or areas in our facilities and deploy the appropriate resources that are necessary. We cannot enhance the safety of those who work and live in our correctional facilities 24 hours a day, 7 days a week, or 365 days a year. Operating prisons and supervision with such outdated technology is a serious issue. We're dealing with 21st century problems and we need 21st century solutions. So let's take security for example. It's nearly impossible for us to track where there may be pockets of disturbances based on the time of day, the location, the amount of officer coverage that we have, due to the fragmented reporting and tracking systems that we have. We're only able to track the disturbances by combing through daily incident reports and then searching through and combining those with the historical reports. It is 100% a manual process, taken away from the actual jobs that we do in the facilities. Or let's think about discipline. We have no ability to track and incarcerate a person's discipline without reading narratives for these instances. We cannot automatically track situations where staff is assaulted and to what degree the assault occurred. That is also a manual process. Further, we are unable to track or report any instances that occur in or outside of the facility and what impact this may have on the other. For example, say an incarcerated person is released and commits a staff assault in the community on one of our agents. That information is not captured as a discipline instance, but is contained in the hearings and release unit's narrative. That would cause the individual to be revoked and returned back to prison. Our systems do not talk to each other, resulting in massive gaps in communication and information. For my colleagues who are case managers and are responsible for the release plans of those who are leaving our facilities, there's no comprehensive way to gather all the information they need. Much of it is in various systems and exists within the case notes. These can take hours to comb through for needed information. For reference, we release 5,000 to 6,000 people out of our facilities a year. So the volume that my colleagues are dealing with for release plans is incredibly high. So Mr. Chair and members, I'm here today because we, the staff responsible for some of the hardest work in corrections and the ones that have been on the front lines during the pandemic, are struggling to keep up. The number of man hours it takes to work with antiquated systems we're dealing with could be much better used to do our jobs. I'm here today so that you can see those of us who are dealing with the impact of the lack of investments in the technology modernization within the DOC. I know I speak for my colleagues when I say that we implore you to support this request. Unfortunately, I do have to get back to the facility as I have work waiting for me. but I can stick around for a few minutes if you do have any questions. Otherwise, I will hand it back over to the commissioner. In closing, I want to say that I'm grateful for the opportunity to be able to speak to you today. Thank you.
Thank you, Captain Mitchell. Chair members, I want to thank you for your attention today to these important public safety investments. I sincerely appreciate your consideration as we enter the final days of the session and the negotiations that will be forthcoming. I will remain here today to answer any questions when the committee gets to that point. Thank you for your time.
Thank you, Commissioner and Captain. And since you're leaving, Captain, I'll see if any members have anything specifically for you. It doesn't mean we won't be talking about this. I really want to express my appreciation for sharing how these requests make a very real, upfront, personal, professional difference for our professionals in our systems. It's often tempting for us to look at these kind of requests as bureaucratic requests, but you're painting a powerful picture of the safety and well-being of our professionals and our systems relative to these data technical requests. Thank you very much.
Thank you.
Thank you, Commissioner. With that, we will move to County Corrections provisions highlights. So a good segue to that. We have several elected officials, colleagues who will join us here today. I show Jack Swenson from Roseau County. Is that correct? Not seeing movement.
That is correct, Mr. Chair.
Oh, very well. You know, that kind of makes sense. I've driven the Roseau. It takes a while to get there. And it makes sense that you're here virtually with us. County Commissioner, welcome.
Thank you, Chair, and Chair Limmer and members of the committee. Thank you for this opportunity. I am Jack Swanson. I've been a Roseau County Commissioner now for 16 years. I also currently serve as the Association of Minnesota Counties Public Safety Policy Committee Chair, and 5 years doing that. And on a more personal note, my younger son works as a probation officer in another part of the state of Minnesota. So just a very brief background. Roseau County, our supervisory system is with the Department of Corrections, and we're one of about 30 DOC counties in the state. In extreme northern Minnesota, there are DOC offices in Roseau and Thief River Falls, each with about 10 agents, and those approximately 20 agents cover about 20,000 square miles. So what I'm here to say today, and it'll be brief, is thank you for the proposed supervision funding increase, which is supported by all three delivery systems, and Commissioner Schnell referenced that earlier. Equally important for us, though, is the funding formula, and for us, that is to say local counties particularly, an adjusted formula would mean greater local control and more collaboration between both counties and their supervisory systems. So the Association of Minnesota Counties supports the funding increase and the funding formula change. We also support the proposed policy changes, as does the Minnesota Sheriff's Association. But I will say that counties intend to implement those policy changes anyway. So funding form, I guess it's not a surprise. The funding is incredibly important for us. And the funding formula change is equally important for us. So with that, Mr. Chair, I'll say thank you very much for the opportunity. I will be here to answer any questions later if they're not terribly difficult. Thank you so much.
Thank you, Commissioner, and thank you for your offer to stay around for a bit to see if there are questions and clarifications with you. Appreciate your testimony and your work. Next, we have Barb Weckman-Brecky, I believe it is, or Breck, Scott County Commissioner. Good morning. Welcome to the committee.
Good morning. Thanks, Chair Mariani, Chair Limmer, committee. My name is Barb Weckman-Brecky, and I'm a Scott County Commissioner. I want to say thanks to both the House and the Senate for including components, the community supervision priorities that counties have requested. I'm also here on behalf of AMC and Micah. Scott County is a Community Corrections Act county. It's important for me to speak about the current inconsistencies even within the CCA formula, which is largely viewed by those involved to be the preferred funding approach. A hold harmless amount was established as part of the CCA formula. This meant that investments to date were frozen. A portion of the formula was locked into place for us. In Scott County, our population has exploded. This growth has not kept pace with the CCA formula. Scott County has about 10,000 fewer people than Stearns County, and we received over $1.3 million less in 2022 for our subsidy for community corrections from the state. Now, my good friend from Stearns County is writing back, so nothing against her, but it just shows the inconsistencies with this formula. This difference is due to both a lack of legislative funding coupled with the fact that the current formula no longer works for Minnesota. This formula is dictated by current state statute. We can't change this. We need your help to change it. Scott County's growing population means new challenges with crime, programming, treatment demands, and staffing. By definition, CCA counties supervise people who commit felony, gross misdemeanor, and misdemeanor offenses. We also supervise juveniles. I need to underscore that we are expected to supervise people who commit felony offenses at a funding level that is inconsistent based on our population. We have over 1,200 people on felony supervision. This is really important to public safety in the counties. There may be concern about that the proposed formula is an inflator formula, but it is not. The one proposed formula for each of the three systems is meant to put the DOC and the counties within the same legislative allocation for supervision and ensure that we all rise and fall together with funding. The counties are not opposed to additional work with the legislature to strengthen this language and intent. I'm very proud of the work our staff are doing in Scott County to work with people with behavioral health challenges. I'm proud of what we've been able to do with our smaller piece of the pie. But as a county commissioner, I owe it to my community to speak with you all today and ask for more tools. Throughout this session, you've heard from local law enforcement that we are in a crisis, that we cannot wait to act, and they are right. As a county commissioner, I can tell you that we face serious challenges at the local level, and putting off the important work of updating this formula is not an option. Your partnership's important to us as we achieve the balance in state and local control. So I'm really just asking for a path forward. We need your support and investment in community supervision resources. They're an investment in a safer Minnesota. But we also need a way to make progress toward a more sustainable and equitable formula to give every county the ability to make supervision decisions based on what is best for our communities. So I'm here today to ask you to trust us and our voices. We are here fighting for a supervision system that is consistent, that is fair, and resourced enough to hold people accountable. We're fighting to continue this good partnership that counties have with the state to do this very important work. So I'm asking you to compromise, do what you can, take some of each other's vision and make it work for all of us. We can't afford to fail at this. And most of all, just thank you. Thank you for choosing public service. Thank you for this hard work you're doing every day, but especially in the next 8 or 9 days. And I look forward to questions. Like Commissioner Swanson, one of my heroes, I'll defer the hardest questions to our staff. We have several county community corrections supervisors, probation directors in the audience today, and they would love to tell you more about their jobs. So thank you very much.
Thank you, Commissioner. Appreciate your testimony. Appreciate your public service, your willingness to serve the public, and appreciate you reminding us of the powerful way in which these counties across the state and different systems came together to propose some vitally needed changes. Hopefully we can respond powerfully to that. Thank you. With that, we have Otter Tail County Commissioner Kurt Mortensen. Commissioner Mortensen, welcome.
And thank you. excuse me, Chair Limmer, Chair Mariani, and members of the conference committee. I am Kurt Mortensen. I am a county commissioner from Otter Tail County, located in west central Minnesota. I appreciate the opportunity to share a perspective of a county commissioner from outstate Minnesota, but also as a former prosecutor from Otter Tail County. Otter Tail County is a county probation officer county, a CPO county. Firstly, thank you for including the funding increases for community supervision in both the House and the Senate bills. Given Minnesota's heavy reliance on locally controlled supervision, this investment is a key component in addressing the current policy safety crisis that is facing our state. By statute, the state is required to reimburse our county of eligible supervision expenses by 50%. We have not had the resources to bring that percentage to its statutory commitment in over 20 years. The Senate funding level finally does that, and we are thankful for that investment. Please do not let this extraordinary opportunity to support community supervision pass us by. Our CPO county is a champion for diversion and preventing people who commit misdemeanor and other serious non-felony crimes from becoming felons. A new funding formula puts our county in a position to prioritize local diversion and treatment needs. It gives us more tools to work with our DOC officers in the field and to help people get a second chance and to avoid going to prison. I do have to say that the elimination of the fees for supervision of misdemeanors in the House bill is a big problem for CPO counties. I appreciate the goal and likely the intent behind it as well, but it exacerbates our funding challenges and is unsustainable. If you want counties to evaluate best practices, address revocation rates and recidivism, find a way to keep our counties at the table to develop a new funding formula, support our continued collaboration, and do not penalize us for wanting the state to fund its fair share of our supervision budgets. Counties and all three delivery systems want community supervision to be a part of your public safety solution. Please meet us halfway and come together from each of your current positions and pass the financial investment at the Senate level and the original policy ask. We need to do better by all Minnesotans. In closing, you have heard from a couple of us today, and we appreciate the invitation to address the conference committee. Behind me and online are many of my fellow commissioners and local supervision directors. We are united in our belief that in order to truly improve supervision outcomes and reduce the number of repeat offenders and their victims, counties must rise together with equal opportunity to provide effective services and supervision that keeps our communities safe. So please come together and agree on a middle ground between your two approaches and help us make progress this year. Thank you.
Thank you, Commissioner Mortensen, and thank you for the powerful message. Quite frankly, I would argue historic unity, not that there was horrible differences and shoving among the different systems in different counties, but I truly think it's a powerful moment when all 87 of our counties can come together under a pretty powerful set of recommendations, including funding, but also formula changes, as well as moving forward with very, very important policy. Obviously, this is very important to you because you drove from central Minnesota,
I did.
west central Minnesota.
You were absolutely right in the uniformity in terms of all counties and all delivery systems, so thank you.
Greatly appreciate your presence and your work, sir. With that, members, we're going to move to a conversation of the county attorney provision highlights. And we'll begin with County Attorney Catherine Losbach of Clearwater County. County Attorney, welcome. Oh, I see Bob Small coming forward, which is always a good thing. Welcome, sir.
Thank you, Mr. Chair. Chair Mariani, Chair Limmer, members of the conference committee, my name is Robert Small. I am the Executive Director of the County Attorneys Association, and I want to thank everyone for allowing our association to testify this morning. What we would like to do is share with you our association's priorities as they relate to the discussions that you will be having, and then also talk about the prosecutor reporting requirements contained in the Senate bill, as well as the information gathering task force that is in the House bill. With me to my left is Mark Metz. Well, Mr. Metz is the Carver County Attorney, and he is the current president of our association. To my right is Clearwater County Attorney Catherine Losbach, and with the chair's permission, I'd first turn it over to Mr. Metz. Mr. Chair.
Very well. Welcome to the committee, Mr. Metz.
Yeah. Good morning. Thank you, Chair Mariani, Chair Limmer, members of the conference committee. My name is Mark Metz. I'm the Carver County Attorney and the current president of the Minnesota County Attorneys Association. Our association has 3 legislative priorities, which are either in the Senate bill, the House bill, or both. And I'd like to talk about our priority of a change in the thresholds for fentanyl that would equal the current thresholds for heroin. And this is included in the Senate bill, but is not in the House bill. We strongly support the Senate provision and urge that it be accepted by the conference committee. If you think about what we do and what you do, our core is to protect lives. And with this change, it gives us the tools as county attorneys, as prosecutors, certainly to affect lives and protect public safety and protect lives. Fentanyl is killing Minnesotans. Almost daily you read about this horrific drug. Just this year alone in February, you may have read about a man being charged in Hennepin County with third-degree murder and furnishing fentanyl-laced pills, resulting in a woman's overdose death. Or in St. Cloud, where 1 person died and 8 others were sickened from drug overdoses involving fentanyl over a 2-day period. And then in April, there was the mother of a 3-year-old boy who died of a fentanyl overdose, who's being charged with manslaughter. You take in Carver County, probably the most famous fentanyl overdose case, certainly in Minnesota, if not the world, in Prince's death in Chanhassen. You know, with Prince's death, we weren't able to determine who provided that fentanyl that killed him. He thought he was taking Percocet, but it was laced with fentanyl. And back in 2016, it was likely that the fentanyl was coming from China on the dark web. And now we're seeing that fentanyl, a lot of fentanyl, most fentanyl is coming from the drug cartels in Mexico. So we look and we see this happening throughout Minnesota, in Mankato, Duluth, Rush City, Becker, Chanhassen, the list goes on. And it is clear from the available data that fentanyl is far more potent, far more deadly, and it's sold for far more profit than heroin. And yet, the threshold quantities needed for criminal prosecution of the sale or possession of heroin are significantly less than those for fentanyl under current Minnesota law. This serious problem needs to be fixed. Minnesotans cannot wait to see more time go by without action and for more deaths to occur while a task force examines the issue. Recent data from the CDC and prevention shows that 100,000 people who died from drug overdoses in the United States between May of 2020 and April of 2021, almost 2/3 were linked to fentanyl or similar opioids. 2/3 of 100,000 deaths from this deadly drug which essentially people are playing Russian roulette with. Because the heroin and other drugs are being laced with fentanyl, and it's just killing people because it is so potent. And you know the statistics, 50 times greater than morphine. It's a really, really dangerous, deadly drug. And we're seeing it as prosecutors, law enforcement sees it. And so that's why we're asking for this action. And this bill provides for the same weight threshold amounts of heroin under our state's criminal laws. So for these reasons, the Minnesota County attorneys strongly urge correction of this problem by lowering the threshold amounts needed for prosecution of the possession or sale of fentanyl to be no greater than the threshold amounts of heroin under our state's criminal laws. In addition to holding fentanyl dealers appropriately accountable for their possession and distribution of this extremely dangerous substance, these changes will allow nonviolent, chemically addicted offenders to get the treatment that they need to overcome their addictions through drug court and other diversion programs. And most importantly of all, these changes will result in more fentanyl being removed from the streets, which will save lives. Our association implores this conference committee to get something done this year and to start, if you have to, start with dealers. That's easier to get done now. But please, please, we urge you to take action now. Next, with the chair's permission, I'd like to talk very briefly about another of our priorities, an increase in county attorney training funding. I want to express our association's sincere appreciation to both the Senate and the House for supporting prosecutor training by including it in each proposal. Prosecutor training has never been more necessary. We're at a midst of a retirement wave in county attorneys' offices, and obtaining quality, high-quality training statewide is a top priority for us. I'm sure that all of you there, and certainly myself and others, are in these positions because we had great trainers, we had great mentors. And it's absolutely critical that we have this training for our county attorneys, because we don't want to see the high priority of our attorneys getting trained on the job. And in the past, they've had federal training available in South Carolina at the National Advocacy Center. And it was a great program where there were grants for state prosecutors to go and take a week of intensive training with other colleagues. And I think I did that 5 different times. And that training was equal to about 3 jury trials that we got. Well, that went away. And so what the County Attorneys Association did is we started our own training years ago, I think 2, 3, 4 years ago. And so the money that is proposed is really essential. The state also used to have the Bemidji Trial School, where we would have 20 prosecutors and 20 public defenders go to Bemidji, stay on campus in July, sleep in a dorm, have the green shade carpeting, return back and have this great training. And we learned a lot from that. And so I use these as examples to show the members how important it is. The House and Governor have proposed a $25,000 increase, while the Senate includes $100,000. Now, we asked for $25,000, but of course, we'd prefer the Senate proposal, as the additional resources will be directly contributing to the association being able to make strategic and impactful advancements in training Minnesota's prosecutors. We're going to be able to bring new prosecutors to this trial school at Camp Ripley and employ an effort to train the trainer to account for our retiring workforce and ensure we continue to provide the education and skills-based training our lawyers need to contribute to improving the quality of justice in Minnesota. And to leave you with this sense of the need, last week we opened up our trial school class, and in 1 hour we were full. We had a wait list of 15 people. And the same holds true for Train the Trainer course. So please, include the $100,000 in your final bill. Now, with the chair's permission, I'd like to turn it over to Clearwater County Attorney Catherine Lorsbach to talk about another of our priorities, an increase in funding for the Attorney General and to expand the Attorney General's criminal division. Thank you.
Thank you. Welcome, County Attorney Lorsbach. Good to see you.
Good to see you as well. Chair Mariani, Chair Limmer, members. Good morning. My name is Catherine Lorsbach, and I'm the Clearwater County Attorney. The effort to provide adequate resources to the Attorney General for a complete criminal division is one of the MCA's 3 priorities, in addition to the training and fentanyl bill that have been addressed previously. I'm here to discuss why this funding is backed by our association, especially rural county attorneys like me. My office is not uniquely small. Over half of the offices in the state are staffed by 3 attorneys or fewer. 24 of those offices, like my own, have just 2 attorneys who handle everything. We aren't able to specialize like larger counties. We can't have a trial team or a homicide division or a white-collar specialization. We must be competent in all areas of practice. The Attorney General's office is an incredible resource for counties like mine. We're able to request their assistance on high-level, complex litigation, especially in cases where, though not constrained by talent, we're constrained by limited hours in the day. I'm here on behalf of the County Attorneys Association to tell you my experience working in cooperation with the Attorney General's office has benefited the victims of Minnesota. We're not looking to cede our prosecutorial authority. We're asking that you grow a division of an office that benefits the victims of Minnesota and provides assistance to smaller offices like mine. Between 2020 and 2021, Clearwater County was rocked by 2 murders and several first-degree criminal sexual conduct cases. This was in addition to our regular caseload. We learned our school resource officer, a longstanding deputy in the community, beloved by the community, was using his position of authority to sexually abuse children at the school. Several victims came forward, and due to the inherent conflict and complexity of the case, neighboring county attorneys' offices weren't able to accommodate our request for a conflict attorney. We contacted the Attorney General's office, and Aaron Eldridge has been helping us secure convictions and has worked tirelessly to ensure that his victims are afforded justice. Shortly after these reported assaults, Dawn Swenson was murdered in her home while canning apples. On the night of September 7th, the defendant broke into the victim's home, and although he was tased by law enforcement, he stabbed her twice before he fled. It was a horrific case. It necessitated a grand jury and a jury trial. Again, constrained by resources and in light of the unique circumstances of the case, we contacted the Attorney General's office. John Gross was sent to aid us in that prosecution. In tandem with Attorney Gross, my office was able to impanel a grand jury who returned a bill on first-degree murder. And after significant motion work, we were able to try the case to a Clearwater County jury who returned a unanimous guilty verdict. We were able to secure a life sentence and provide peace to Dawn's family. To quote Judge Tiffany, Dawn was a jewel of Clearwater County, and we are proud of our partnership with the Attorney General's office that it led to a successful conviction in her memory. We're asking for these funds to be made available to the prosecutorial division so that on unique high-level cases, assistance remains just a phone call away. The victims of Minnesota deserve the highest level of justice and accountability that we can provide, and these funds will go a long way in supporting our commitment to them. I thank you for your time and allowing me to testify today.
Thank you, County Attorney Lorsbach. Judge Small.
Thank you very much, Mr. Chair. Mr. Chair, I'd like to address the prosecutor reporting requirements contained in the Senate bill and the task force on the collection of charging and related data provisions in the House bill. Our prosecutors continue to question the adequacy of the approach contemplated in the Senate bill as it relates to the dismissal reporting language advanced by the Minnesota Chiefs Association. Now, you may recall that the testimony you heard last week from the Maple Grove Police Chief was about cases not being charged. Cases not being charged. He also told you of one instance where he questioned the adequacy of a plea agreement. So the chief presented testimony about cases not being charged, inadequacy of a plea agreement. Folks, the Senate bill does not address the concerns expressed by the chief or by the Chiefs Association. And I've told them that. The bill talks about cases dismissed and reporting of cases dismissed, not uncharged cases, not inadequacy of plea agreements. And I've told them that. And I told them that if that is their concern, this bill doesn't address the concerns that the chiefs have been talking about. So, secondly, this bill comes with a huge unfunded cost that I'm sure the commissioners sitting in the back of the room would be very concerned about. The estimated cost of the unfunded mandate that will be placed upon counties is estimated to be in excess of $11 million. I circulated the provision of the Omnibus bill to our membership. Within hours, I heard from Wadena, Wilkin, Sherburne, Couchiching, Mauer, Faribault, Ottertail, Rock County about the costs that their counties would need to absorb in complying with this bill. I also heard, in addition to those counties, we have 15 part-time county attorneys. Those county attorneys do not have a website. This bill requires reporting on a website. There is no website, and that means that at least in those 15 county attorneys' offices, those counties will have to create, maintain a website in order to comply with this bill. Thirdly, the reporting data is partial data, and it has the huge potential to be misunderstood and very misleading and misused. Prosecutors often charge multiple counts arising from one behavioral incident. That's a common practice. So a person may kill somebody and be charged with A, third-degree murder, and B, second-degree manslaughter. Under the law, currently, a person can only be punished for one offense. So if there is a plea agreement to the third-degree murder charge, the highest count, and the second-degree manslaughter count is dismissed, what is reported to the public is that an assistant county attorney dismissed a manslaughter case. That's misleading. That is misleading, inaccurate, and does not help understand what prosecutors do. So that is the information that I wanted to communicate about it being misleading and the potential to be misused. We believe that the criminal justice system's collective responsibility to administer and participate in constructive, system-wide information gathering and analysis should be done in a collaborative, goal-oriented fashion that is focused on system improvement and justice for all. We think that the task force in the House bill better accomplishes that goal. One last thing, Chair Mariani and Chair Limmer, as we go into the last week of the legislative session, and this group is charged with contemplating important public safety policies, we would bring to the committee's attention a way to enact the competency restoration bill, which was passed by the House last week on a significant bipartisan basis, and which the Senate is currently reviewing. So with that, we would be available for questions. Thank you.
Thank you, Judge Small. And so we will open this up for questions. You might as well stay there because we might well just start with you all as well. And Chair Limmer, my hope is that we can get through, a good, discussion and question and answers, but then also a discussion on considering the House recommendations that we move forward with several, we really should be non-controversial, even in some cases housekeeping items. I do understand the argument that, boy, we really need to be focusing on the big stuff, quote-unquote big stuff. I mean, everything's important. I totally understand that. That is part of our work, but so is this. And my fear is that as we get into the quote-unquote big stuff, some really important things, can wind up withering on the vine, and would be a shame if those important things are actually things that we have every reason to agree to. So one, for instance, is, the possible expansion of the doxing provisions to apply to prosecutors, judges, public defenders, and correctional employees, two of those groups we heard from here today. But let me begin with questions that do have the beginnings of a list here. I also just want to say, County Commissioner, County Attorney Metz, the House had a good hour debate on the fentanyl provision. I heard your words. I was listening very carefully. Your recommendation that, one, we should act, and two, that starting with dealers is a really good place to act. That's precisely the amendment that we debated on the floor of the House, and we actually passed on the floor of the House. Unfortunately, our minority party had the underlying amendment that would have applied in all instances, and then withdrew that. So we do have a House position that reflects a discomfort with taking the full big step, but certainly is open to conversations with the Senate here relative to the parameters that we laid out in the amendment that the House passed. And again, which subsequently was not put into the bill by virtue of our minority party moving the entire amendment away. All that to say that there's always room for all sorts of really important conversations and movements here. Let me begin with Representative Moeller, and then I'll jump over to Senator Bingham. Representative Moeller.
Thank you, Mr. Chair. And I would like to, with your permission, address actually 4 topics that they went into. And I'll start first with the Senate reporting requirement for prosecutors. And also one of the things that I noticed in that language was that it required line attorneys, assistant county attorneys, to actually have their names posted on that website. As many of you know, I work at the Hennepin County Attorney's Office. When I don't do this job, we are having a workforce shortage like many other employers, and particularly in the division that prosecutes violent felonies. And I'm just curious what you think that language requiring individual line attorneys' names to be posted on a public website would do to your county's ability to hire prosecutors.
Judge Sloan.
Mr. Chair, Representative Moore, we are in a hiring crisis. I mean, that's no question about that. We spend time at the law schools trying to attract people to county attorneys' offices and to careers as public prosecutors. And we, like the police, are not getting overwhelming number of applicants, particularly in greater Minnesota. The example that I gave that Robert Small dismissed a manslaughter case, and that gets published on the public website and is known in the Fergus Falls newspaper or whatever, that is not going to draw people to want to work in Otter Tail County or Coochin County or anywhere, including Hennepin County. And so I think it would have a horrible effect to post individual names when there is a potential to mislead. I don't think county attorneys shirk from the decisions that they make, the very hard decisions that they make, but not having the ability to give a full description about why they did what they did is bothersome and worrisome.
Representative Muller.
Thank you, Mr. Chair. It looked like County Attorney Metz had a comment too, if that's okay.
County Attorney Metz.
Thank you, Chair and Representative Moeller. Appreciate that question. From my perspective as elected official, I think that's what we sign up as elected officials, that you're going to be criticized, you're going to be in the public eye. That's a necessity. It should be allowed, but our assistants, they don't sign up for that. That they're not elected, they're doing the day-to-day job, day-to-day work. And I think we've seen an increase. I know we've seen an increase in harassment and attacks on our elected officials, but very importantly on our staff attorneys. And they harass in other ways through social media. And so that would be the effect that people go into the business and say, why do I want to go and be a prosecutor or an assistant county attorney when, my family can be affected and others can be affected? So I think that's a really good question.
Well, thank you. Representative Muller.
Thank you, Mr. Chair. And I do have a question for Mr. Metz about the fentanyl provisions too. And I think, Mr. Chair, you talked about how, the sale level, that was something we were going to take on the House floor, first-degree sale, and that there's really a difference between sale and possession. And I think one of the things that concerns me about the possession offense is that the way our controlled substance statutes are written, someone can be guilty of possessing because it's a mixture. And so let's say somebody thinks they're buying marijuana, it's laced with fentanyl. They don't want fentanyl, they don't know it's got fentanyl in it, but now because it's got just that little bit of fentanyl in it, they're facing a felony level when it was something they didn't know or want, which is very different from someone selling fentanyl to people. And, I just wanted to get your opinion on that. And that's correct, right? If you have a mixture and it's a small amount and you don't know it's in there, you're still going to be guilty of possession.
Briefly, Mr. Metz.
Yeah, Mr. Chair and Representative, that's true. The statute talks about a mixture that you have. And I think what's important too is we're dealing with a really deadly drug in fentanyl that mixed with these other drugs, and that's what happens. It's mixed with cocaine or mixed with heroin, and other times it just has other agents of baking soda. But I think, a large part of that is certainly using good sound discretion as prosecutors when assessing every case, which we do. But that is part of what already is in the provisions, is this mixture.
Representative Muller.
Yeah, thank you, Mr. Chair. And I don't remember the case law on this, but there's a bong water case that reached some infamy years ago. And so I understand prosecutorial discretion, but just to let you know, I have some discomfort with that, the language as it's currently drafted. I will mention that I am a big fan of the trial school. I am a graduate of the trial school. I won't tell you when. It was many, many years ago. And my colleagues got great value out of participating in that as well. And then finally, I just wanted to address the funding for the Attorney General's office staff. I'm also an alum of the Attorney General's office. I worked in that criminal division for 13 years, and I handled felony level appeals from all over the state. I did some trial work and some civil commitments. I was in Cottonwood County to interview witnesses, and I went in a ditch and a farmer pulled me out. It was one of my fondest memories. But what I will say is that the work that office does is so important, and I really appreciate your comments and the letters. And to my colleagues, we have letters in our packets from Todd County, Freeborn County, Cottonwood County, and Cook County as well. Some of the high-profile cases when I was in that office included the murder of 12-year-old Callie Jo Larson out of Waseca, the Rocori High School shooting, the Zabawa case out of Waseca. I handled many appeals for across the state, including one for Washington County. It was the Van Curran case, where Van Curran killed his ex-girlfriend and her boyfriend in front of her 12-year-old child. And our office handled the Donald Blum appeal. That was the Katie Poyer case. We handled numerous sexual assault cases that were precedent-setting. The kinds of time and detail we could put into some of those complex appeals that actually make an impact on the evidence that's able to be admitted in sexual assault cases continuing to this day. That work is really important. There's a great collaboration between the Attorney General's office and the county attorney when they go in. And basically, when they're going in for these trials, they're pretty much embedding themselves in the counties for a period of time to prep for trial and to handle those cases. And it's really, really important work, and it's important work for the entire state of Minnesota. And I really hope that'll make it across the finish line. Thank you.
Hope so. Thank you, Representative Muller. Senator Bigham, and then Chair Becker.
Thank you, Mr. Chair. I echo everything that Representative Muller said about the importance of those provisions, but no offense, I don't have any questions for the lawyers. I do have questions for the county, the community corrections folks. So maybe if the previous testifier can come up. And while that's happening, I just want to give a warm welcome to Commissioner Swanson, who's just a peach of a person in Roselle, and appreciate him making time today to talk about this. We served on the Public Safety Committee for AMC years ago. My question, I'm just going to start with a statement that if this committee wants to have an immediate indirect impact on making communities safe, we need to fully fund community corrections. It has been underfunded for decades. It is a shift and a slight to counties and to property taxes. And we need to make this right. I have spoken to both the chairs about a couple ideas that I have that I think can help meet in the middle. And the other thing I want to say is I believe the counties coming forward asking for this change is a very important step. I don't think people understand the significance of when 87 counties can come together and agree on something. The only other time I believe I have seen that is when we changed the CPA formula, which was an agreement with the LGA formula, and that was direct property tax relief. So I'm going to keep saying that this is direct property tax relief as well as an immediate impact to making our community safe. We have talked a lot about the formula, but there are other things outside the formula in Article 7 of this bill that I am wondering if people can speak to on the community corrections article of this bill.
Please state your name for the record and
All right, thank you.
engage with the question, please.
Thank you, Mr. Chair. My name is Carly Stark from the Association of Minnesota Counties. Unfortunately, Commissioner Weckman-Brecky had to leave, so I came up just in case I could answer questions. I also have Jason Anderson here, who is a probation director and can answer things related to specific probation questions. Well, first, we want to thank both chairs for making community corrections a highlight this year. We do agree with the formula, but we have concerns about the additional provisions that Chair Mariani and the House added. As our previous testifier said, I understand the intent, and it's good intent, but it does have, those provisions have real effects on counties. One of them was prohibiting supervision fees without having any kind of additional study on how much that would affect county budgets. We've thought of this idea, but without understanding how it will affect budgets, we just don't support it. The other one is eliminating or taking money from counties for every day spent incarcerated for people on supervision. Incarceration is used as a tool for accountability. So there are some counties that have a program called Swift and Certain, which is basically where clients know if they violate their probation in a certain way, they get this many days of incarceration. And we think that those tools are imperative for accountability and supervision and rehabilitation. So if money is taken away from counties for doing their job, it makes those decisions less focused on public safety and more focused on keeping money in the coffers, and that's not the way we want to do supervision here. The last one, and I think I'm stealing all Jason's thunder, but the last one is there's a provision that weights misdemeanors at no more than half of felonies. I don't know if that's a good policy or not. Our proposal had a workload study in it to ask that very question of how should these different types of cases be weighted, and we've actually talked a lot about weighting based on risk level and not on case type, because a high-risk individual, a misdemeanor domestic violence client who has high risk, high need, still needs a lot of services, so that might cost more, that might cost the same as supervising someone with a felony offense. So Jason, I don't know if you want to add to that?
If I may, Mr. Chair.
Yes, please, very briefly. Good to see you, Jason.
Yeah, likewise. Again, my name is Jason Anderson. I'm the director of Itasca County Probation. And yeah, I appreciate the spirit of it. I think what is attempted to be accomplished by that provision, the idea of compensating or funding probation based on risk level. There are clients we serve that need a ton of our resources, and there are those that just flat out don't. Conviction level is not a measure of risk. It's just not. We utilize validated risk assessment instruments. We've imparted a great deal of science into this social science over the last 20 years or so. And while it might feel intuitive that a felon is just, this ticking time bomb versus this lowly little misdemeanor we should just sort of leave alone. Boy, I'll tell you what, if you look across the landscape of validated risk assessment instruments, the level of conviction is not taken into account in any of them because it just really doesn't matter. We supervise some very high-risk misdemeanors. And I've worked as an adult felony probation and parole officer in my career. And I supervised a number of very low-risk felons. Reform on how we get funded, it's been a long time coming. Adequately funding what we do has been a longer time coming. I would be in great support of allowing what's contemplated in the legislation of the bill, that we revise how we fund stuff. Give us the opportunity to work with you, to work with folks, to decide exactly what that looks like. But I would urge you to not just make that decision based on offense level.
And Mr. Chair.
Senator Bingham.
Thank you for saying that, because I think this is the reason why I feel we need a single formula for all three disciplines. That's kind of temporary, and then form a group. I really don't care what that, who does it. Could be the Bureau of Mediation, could be AMC, could be an LCC, could just be a good old-fashioned task force to deal with some of these issues. And of course, I think we should have legislators on it because, and I'll volunteer. I'm a short-termer, so I can help. But it's important that these issues get vetted out because there are unintended consequences. And so I just kind of want that out there. The other question, more of a concern I have, we have a tendency to do one step forward for our local partners and two steps back. And an example of that is the increase in the Red Wing County Sheriff per diem for counties. From my conversation with Washington County, it's almost a $100,000 shift for juvenile placement in Red Wing. And it would be over $325,000 to Ramsey County and about over $600,000 to Hennepin County. I don't know across the 87 counties, and I know you have the joint power groups in some of the smaller counties that kind of work together, but I'm assuming that's a significant shift statewide to counties. So I don't know briefly if you wanted to comment on that, but that just concerned me a little bit.
Very briefly, I think we heard some testimony on this earlier.
Yes, thank you, Mr. Chair. I think we addressed it in our letter. We do oppose that provision just because it does create an additional county cost shift. And our focus this year has been on the community corrections formula, and we don't want anything to jeopardize the effectiveness of that proposal because we worked so hard on it. So.
Great. Thank you, Mr. Chair.
Thank you, Senator Bingham. Let me just comment very briefly because, we are talking about House provisions. And, first, on the, charging full cost for detaining kids, I'm certainly not going to apologize for having our systems do that. The bigger question, of course, is how is it that we, support our counties? And I think one of the things that both the House and Senate agree on this year is that we're recognizing that we have not met that obligation, either the one that's directly stated in statute and the rest that's implied. So I think there's good agreement on that. You and I had a conversation about, your idea. We did that. We did that last year. We quote unquote kicked the can down the road. We did it all in good faith. Set up a process by which there can be an intelligent, good conversation. And in fact, a historical one was had, I would argue, that then yielded a set of recommendations along the three areas of both, more resources, fixing the formula. We heard from a county commissioner that the formula no longer works for counties. No longer work. Why do we keep doing things that no longer work? It seems to me, us as legislators, our role is to stop doing things that no longer work and then do things that do work. And of course, I think I'm smarter than the average bear, so I want to tell you what that worth, and, I'm getting pushed back on some of that here today, and I can accept that. However, the counties are telling us, what works. And I think we really ought to be paying attention to that. So, Senator Bingham and Mr. Chair, I think the House can meet the Senate in the middle on this, big issue. I happen to like my provisions pretty well. But, what I really like, and I think what the House really prefers, beyond just what the chair here likes, is that we properly resource, this sector in our state, and that we stop resourcing it in such a way that we continue to support a failed, formula. And so I would certainly counsel my conferees that we can meet the Senate, in a place where we're properly resourcing, and we're properly resourcing within the context of the change. Not kick the can down the road, in the hope that change will happen. And let me just say very quickly, had a good conversation with county folks last week. I have a lot of trust and confidence in what you do. And so, my desire to have a connection between major appropriations at this juncture, along with change right now, isn't so much, saying I don't trust you all to do the right thing. It's how we ought to be legislating. And, I'm just never going to apologize for making major decisions of taxpayer, regular citizens, resources that are used to drive effective practices. And Mr. Chair, you and I could talk about where that level could be, but I don't think that the House's position is going to be, we're just going to throw money at the existing system. Senator Bingham.
Thank you, Mr. Chair, and I don't disagree. I would not like that either. I hope we do have some sort of reform, which is why I'm trying to kind of bridge a middle ground. The only caveat I would say to your comments is we've heard that severity isn't indicative of the amount of supervision, and I think that's an important aspect that actually the formula doesn't quite permanently get to. And then I think weighted caseloads and how the additional funding and how the 3 disciplines use those hasn't quite been, I don't know that it's permanent yet, I guess is what I'm trying to say. So I think having an opportunity, now that we know they have the money, now that we know we have the results, to have a group of stakeholders together to fine tune this, I just think is good policy and good use of our dollars. Thank you, Mr. Chair.
Okay. Chair Beckerfield.
Thank you, Mr. Chair, and been listening carefully throughout these committees, and I think one thing, and I've also worked as a prosecutor, not nearly as much experience as my Vice Chair Mueller, but also know what that day-to-day work is like. And I think one thing as I read some of the provisions in the Senate bill and some of the provisions that we've discussed on the House side as well, there often is this base misunderstanding of the way that the system actually works, of the way that our criminal justice system works. It's not law and order. The prosecutor's not out there in the field with the badge walking up to the scene. That's not how it works. There's very, I think most people don't understand what happens between a call to 911 and a case actually being charged, and then what happens after, decisions are made and that court process occurs. Because there's the role that judges play, there's the role that prosecutors play, there's the role that the public defenders play, and defense attorneys play. And, for example, a case may be stayed, but there may be an agreement to other provisions or other ways that we're holding people accountable, to get to that probation side of things as well. And I think something to keep in mind is, a foundational element of the American criminal justice system is that we need to prove something beyond a reasonable doubt. And beyond a reasonable doubt is a really high standard. So sometimes a case might be dismissed for lots of reasons. And to make the deeper connection with the work of the Department of Human Rights, as we saw in those findings, if the body camera footage has elements in that footage that are not going to be helpful overall in a case, well, then we can't use that footage the way we would have used it to hold somebody accountable. Or there are reasons that victims may choose to, no longer participate in a case. I always have at a base level, just have to accept that a victim of domestic violence knows best how to keep themselves alive and safe better than any of us will ever know. And, there have been cases that I have charged that have later been dismissed, and that doesn't mean that the system isn't working. It just means that we've decided as Americans that our freedom and like the burden to lock somebody up should be that high. If it was one of us or one of our family members, we would want that to be that high. That's what makes our country free, and not like a lot of other countries, is that the burden has to be there to take away a person's physical liberty. That is like a base level what it is to be an American. And so I think keeping that in mind, that there are all kinds of reasons that a case might be dismissed, and it doesn't mean the prosecutor didn't care or didn't want that person to be held accountable. There are all kinds of different ways agreements can be made that aren't. So I think this idea that like prosecutors are soft or, not holding people accountable is just not helpful, because really all of us have to work together. I'm very dependent. I mostly worked on GOA domestic cases, so gone on arrival cases, which are notoriously difficult cases because you don't have somebody arrested on scene right there when the cops show up. They're very difficult cases to prosecute. And, when you sit there as a prosecutor, you're very dependent on what the police bring to you. I'm not involved. I'm not, telling them how to do their job. They're doing their job. There's that role to play, and then there's the role of the prosecutor, and there's the role of the courts. And so a lot of the discussion and some of the ways some of these things are drafted, and maybe I had this idea while I was sitting here. We encourage people to do ride-alongs with police officers, and we talk about judges. Spend a couple days shadowing a prosecutor and a defense attorney, and really see what that job is like and how those decisions are made. Because it shouldn't be a decision that's made lightly to lock somebody up, either. Every decision, everything that we sign off on is hard. That's why that job's so hard. That's why people don't want to do it. If you can make way more money in private work than living out in, a rural county and doing something really hard, where, my husband works in mental health, and we talk a lot about, well, the decisions we make at work are actually life or death. They are actually life or death, especially when you're talking about a domestic case. And so that, I just want to make sure we're keeping all of that in mind and making that connection too with what the Department of Human Rights does and their role in the human rights space, as well as we see that overlap with what we know about our communities and what's happening. And you look at what's happened in Buffalo and is happening in other parts of the country right now. And there definitely is that connection between crime and holding people accountable and public safety and Department of Human Rights work with all the work that they do as far as bias and discrimination and sort of IDing where those fault lines are. So no questions, Mr. Chair, but I needed to get all that on the record, because I think we need to take a step back and realize that it's not that simple. It's not Law and Order. I can't just it's not Blue Bloods. You don't go yell at each other in some different room and change the outcome of a case. That's not actually how it works. It's much more complicated than that. And finally, I just want to point out, it's sort of interesting, this idea of making a line attorney's name public, and then at the same time, we have this provision that's trying to protect people and expand the doxing crime. So which is it? Do we want to protect our public servants and their own personal safety, or do we want to have somebody to blame when we're mad about something and have somebody's name in the paper? And so I think those two provisions, particularly as I was listening, are just not, they don't really make a lot of sense. So I just want us to think harder and realize that how complicated this system is, and we do best to understand it better if we're going to get to solutions that actually work and make people safer. So thank you, Mr. Chair.
Thank you, Chair Becker-Finn. Let me pause here. We're 50 minutes away from our regularly scheduled end of this conference committee. Oh, boy, I need new glasses. It's an hour and 15 minutes away. Oh, that's good.
Look at Lance.
Yeah. I can use them for sure, man. Okay, all right. Let me then continue on with our list. Representative Johnson, and then we have Senator Lentz.
Working to get everything turned on. I need to get turned on here. Chair Mariani, Chair Limmer. First of all, I want to start with the county attorneys. I'm not going to ask you any questions. I just want to make some comments. Of the 87 county attorneys across the state that are elected, I believe 85 of them are doing a fantastic job. These issues were brought up because of two county attorneys refusing to prosecute certain crimes. Yes, they have prosecutor discretion, but that's supposed to be case by case, not a blanket policy. And that's why a lot of these issues were brought up. To show sunlight in what some of the county attorneys are doing, mostly just two of them. In Minnesota, our population is roughly around 5.7 million people. 1/3 of them live in Hennepin and Ramsey County. So the Hennepin and Ramsey County attorneys and they are handling well over one-third of the cases across the state. And so that was the basis for that, because they were refusing to do their duties to keep the public safe. And sunlight was needed. Now, I understand your position on fentanyl. We need to do something. Fentanyl is killing hundreds of thousands, or close to 100,000 people across this country every year. With it end up being over 108,000 overdose deaths, with 2/3 of them being fentanyl related. Now, I'm in favor of the possession part of it, for the simple reason it's an opportunity to get those individuals, instead of through the court, getting them into the court system, but by giving them a way out, by getting them the treatment they need. If we get people off the fentanyl, the drug dealers aren't going to be here. We need to work with the addiction problems that we have, and not just in fentanyl and meth, alcohol. We have an addiction problem we need to deal with. And I've lived that with my brother, who is an alcoholic, Our family worked for decades trying to get him the help he needed, but until he got caught with a DWI and a child endangerment, he never was able to get that treatment. But because of that treatment, I believe he is still alive today. So I'm in favor of the entire fentanyl bill. It's that important. It's going to save lives. So we need to work on that. And the other thing, the prosecutors, I think, in most counties, they do a good job of. And that's working with our law enforcement officers to train them on what they need to do a proper prosecution. Because without the law enforcement officers in step working with our prosecutors, it's hard for them to do their job. And our law enforcement officers want to do their best because they want to keep those who are committing violent crimes off the streets. I am concerned about the funding for the Attorney General's office. It was unfortunate that the DFL Attorney General Lori Swanson dismantled the Criminal Justice Division and used those funds elsewhere. And now we've got to spend funds that are supposed to be used for that again. But my concern is the way our current Attorney General has been taking the lead in the cases. If you read the statutes on the Attorney General, there is no criminal division, no criminal authority. But they do have the authority to assist, not lead, but assist county attorneys when needed if resources are available. And over the years of my career in law enforcement, the county attorneys, or the Attorney General's office, years ago, did a good job of that. But again, now I have concerns with our current Attorney General overstepping his authority and taking over the lead on cases when he doesn't have the authority to do that. With that, I'm going to leave it there. I understand there's still is some contention in the probation issue. I've talked to numerous county commissioners on this, and they do have concerns on the current proposal in the House bill that need to be addressed. We do have a responsibility in state statute to provide 50% of the funding, which we are only at 29%. And so we do need to get that back where it belongs. So with that, I'll turn it back over to the next speaker.
Thank you, Representative Johnson. Appreciate your comments. I do have Sarah last. Before I do that, Chair Limmer, I need to figure out how we're going to use the next a few minutes here. My understanding is the Senate, you're still on the floor, you're going back on the floor. I know that Sarah Oswald has some important responsibilities to meet on the floor of the Senate. You know, sir, it really is my very public and transparent, publicly transparent desire and attempt to build a bill here. We have provisions that we've identified. I had staff up pretty late last night plowing through not controversial stuff, but non-controversial issues. I mentioned earlier, you know, there's a doxing provision that's actually a Senate provision. We've heard from prosecutors and correction employees here today, for which I think this provision would make a difference. I prefer that we move these items, you know, as a package, because I don't think we need a ton of debate on this, but obviously, you know, we can do it either way, but I really badly want us to be building a bill. And I understand the call for, you know, big stuff. My door is wide open for big stuff. I've not seen any big stuff coming forward, and so my desire, quite frankly, has been to just sort of let's gently get there, you know, because we have two parties in control of two different houses, trust levels, you know, those kind of things, you know, they just get in the way. You know, the other day we heard testimony from someone that, you know, looked to, you know, drive even greater divisions. You know, thankfully we, you know, we resisted that. So for me, it's about how do we move things forward? And so, Mr. Chair, before I take any action here, I guess I turn to you for your guidance and counsel and expression of what your will is here today. My will is that we ought to keep building this bill. And I think we can do that by doing things that we can just get out of the way here. We've got a good basis, upon which we can then do the tougher work of the bigger issues. So, Mr. Chair, I turn to you.
Thank you, Mr. Chair. A couple different subjects in all of that. First, might want to remind you that I made an instruction to the Senate members in light of the Senate going into session at 11. I wanted all of our members to stay here and continue the meeting. Now, Senator Osmek has a unique role in the Senate, and I know that he has to leave. We can continue our discussion for a few minutes, but nevertheless, I believe that Senator Osmek would be coming back, and maybe Senator Osmek could make a comment about that, but we can continue with our discussion. So, Mr. Chair.
Mr. Chair. Certainly would be helpful. Thank you, Mr. Chair. Senator Osmek.
Mr. Chair, I do have a question. When I come back, I have a question for the Department of Human Rights, but we can come back to that. My plan is, in the next couple of minutes, to go across the street, open the session. There's some perfunctory items that we need to get through, and we are supposed to go to recess. So I anticipate I would be back. Perhaps it may take 10 minutes. But I am coming back. I do want to participate in this conference committee, and I also want to be here for any votes that need to be taken. So we're going into a recess. I think it would take maybe 10 minutes, hopefully.
Well, Senator Osmek, thank you for publicly sharing that, sir. I appreciate it. I will resist my temptation to put something in front of us that I think could only take 30 seconds for us to do, because I think it is important. Well, I mean, it's a set of provision that the House is perfectly comfortable with. And so, but the point is, I'll take you at your word, sir, and you're an honorable, respectable, respected legislator, and I want to honor your commitment to come back here shortly. Chair Limmer, it would be my intention that we find a way to move these provisions and take some votes on them before we're slated to be done before noon here today. So why don't we continue the conversation? I'll see you soon, Senator. Thank you. Senator Latz.
Mr. Chairman, thank you. If I had been called right after Chair Becker-Finn, I would have simply said what she said. So I'm not going to repeat any of it. It was stated and probably far better than I ever could have. So that was terrific. But I did have a couple of other comments or questions. One was in response to, well, a couple of them in response to what Representative Johnson had to say. We'll see if I did to him what he did to the county attorneys, apparently, as I can hold that thought if you want to come back in a moment. Anyway, just a little bit of a retort to some of the points that Representative Johnson made, and some of us have heard this before, but I'll just say it again since we're in a public setting and it's in direct response here. One of the concerns that was raised was about Hennepin and Ramsey County apparently being the only two county attorneys in the state that Representative Johnson thinks are doing their jobs poorly. All other 85 county attorneys apparently are doing a bang-up job that is to Representative Johnson's standards. But I would say that all county attorneys, to one degree or another, shape their approach to enforcement and prosecution based upon the standards in their own communities. That's one reason why we have elected county attorneys and not appointed county attorneys. They're not appointed by the governor to implement the governor's standards. They're not appointed by the county boards, although their budgets are controlled by county boards. They're not appointed by the county boards. They're elected by the constituents, the residents there, and the essence of democracy is for people who run for county attorney to be able to share their vision of what the office does, what their priorities are, what their approaches would be toward prosecution and enforcement of the law. And then presumably if there's a contest, the voters choose what vision they want elected to implement that. In Hennepin and Ramsey County, the constituents, I would respectfully suggest, the residents, have chosen county attorneys that approach some of these issues differently than in some other parts of the state. And I think that's their prerogative, that's their right as voters to do so. And if the county attorneys at some point are out of step, then those county attorneys either choose not to run for re-election or they get challenged, and the voters can choose to elect someone else. So I don't have a problem with the Ramsey and Hennepin County attorneys tailoring their approaches to prosecution, the standards that they apply to prosecution, to meet the standards of the community that they represent. I think that's exactly what they're supposed to be doing, even if people in other parts of the state disagree, even if this legislature disagrees. In fact, I would say it would be this legislature undermining electoral democracy if we undermine the prosecutorial decisions, especially the broader themes of their decisions, by overriding that with state statutes. Now, I'm not saying we don't have the authority to do it. We pass the laws, we pass the criminal sentences. On occasion, we pass mandatory sentencing requirements that override the discretion of judges as well as prosecutors. But I think we ought to do so when we do so with a great deal of caution and understanding that we have a form of government that builds in that kind of local discretion and flexibility to meet community standards. One way in which that has been implemented in particular, and this has already come up this year on a number of occasions, is the criticism of the Ramsey County attorney and the sort of the blanket determination he made regarding prosecuting certain kinds of cases. And so there are those who probably know in this room who know the details of this better than I do. But the Ramsey County attorney made a decision to not prosecute certain felony cases, ones that derived from what have been historically and demonstrably in many cases been conducted as pretextual stops. And it was not for the purpose of not holding felons accountable. It was for the purpose of deterring some police officers from conducting stops for objectively, legally valid reasons, but which are often used as pretext to stop someone because of the color of their skin. Driving while black is a thing. Ask anyone who's testified here or in all sorts of other forums about what it's like to drive while black in certain parts of town or our communities. It's a thing. And one way to deter police officers from engaging in those kind of stops is to say, if a stop results in certain charges, we're not going to prosecute those. So you can stop making stops for that reason. Now, the county attorney, Ramsey County, did say if a stop is based on a reason that is a safety risk, if it's a driving conduct kind of thing, that's a different story. But things like objects hanging from the rearview mirror or taillights being out during daytime or other status kind of offenses, he wasn't going to prosecute those. It was not a blanket prohibition on prosecuting all felonies that came into his office. So let's just be clear on what that was. And he was meeting a very specific community need in Ramsey County, in my judgment. Certainly one that a large portion of the community in Ramsey County appears to be supporting. Now, with regard to the fentanyl, I'm on record supporting most of the Senate fentanyl position on this one. I think we need to do something. We needed to do something last year. But I do respect the concern about criminalizing addiction. And when you have the lowest level possession becoming felony or potentially becoming felony convictions that will stay on a person's record for a lifetime, that's criminalizing addiction, and it does not advance public safety. In my understanding, and there are experts probably in the room who know this better than I as well, but I'm not sure that there's a big market for fentanyl as a standalone drug for use by individuals. Now, I might be wrong on this. I can look at the county attorney's office. I'm getting a thumbs up that I'm accurate on this. People aren't buying fentanyl on the street just so they can do fentanyl. If they were, it'd be committing suicide because they can't titrate the doses. They get fentanyl ingested because it's been mixed in with other substances, heroin or cocaine or something like that, and often they have no idea it's there. So that tells me that if they're going to be charged with possession of a serious drug possession, a drug crime, they're likely to be charged with possession of heroin or possession of cocaine, along with the possession of fentanyl. Or maybe it'll be marijuana laced with fentanyl. I don't know that, maybe that's a thing too. But again, probably not what they were intending. So for me anyway, for the lowest level of fentanyl possession crimes, I would support making that a gross misdemeanor. And still, you can use that as a tool, as well as the other charge that come along with it, to get people into treatment. And that is a very positive outcome for many people who come into contact with law enforcement because of the drug addiction. I've seen lives turned around for that reason. But I think we ought to be realistic in terms of exactly how we're targeting our statutory proposals to accomplish the goals that we wish to accomplish without any longer-term negative side effects. The only other thing I'm going to say with regard to what Representative Johnson said was dealing with the Attorney General's office. The suggestion that the Attorney General, this current Attorney General, is taking cases he doesn't have the authority to take or taking over cases. The Attorney General's office is there, has the statutory authority to handle cases at the request of county attorneys. In fact, it's a really, really important job that they have. And yes, when I was there, they had, 13 people, I think, in the criminal division. I think Representative Moeller was there at the time. They had a full division. And they were absolutely some of the best prosecutors in the state. Over time, this legislature did not adequately fund the Attorney General's office's needs to keep their salaries commensurate with what was needed to keep the talent in the Attorney General's office. And so part of what the Attorney Generals did was reduce their staff a bit so they could take the remaining budget and keep the rest of the staff by paying them enough to stay there instead of jumping out to the private sector, where many of them could and some did make 2, 3, 4 times the salary that they were making as public servants. That also did have an effect on the criminal division. And whatever you think of that managerial decision, the fact is we're living in a different world now where cases are more complicated, where we need to have those resources. And circling back to the original point that was made by Representative Johnson, in the cases that the Attorney General's office is prosecuting are not cases that Attorney General Ellison reached out and grabbed away from unwilling county attorneys. They were cases that the county attorneys, and in a couple of cases, the governor, with the governor's very explicit and public encouragement, asked the Attorney General's office to take over. They absolutely have that legal authority to do it. So it's not fair to say Attorney General Ellison engaged in a power grab. On the contrary, he was willing and able to take on some of the absolute toughest and most politically and legally fraught cases in the state at the request of the county attorneys and the governor, who wanted his office to do that. And he made it work with the resources that he has, but he needs more resources to be able to do that when county attorneys turn to him, and we heard some of the direct testimony as to its value. So I just want to make sure, at least from my vantage point, I set the record clear on that. And then I actually had one question, and I don't know if Senator Limmer, Chair Limmer, is willing to address this, but I'd be curious if Chair Limmer is, to share a little bit of his thoughts in response to the Department of Corrections and the Community Corrections testimony with regard to not only the funding but the formula, including the suggestion that was made, the flexibility that one of the testifiers said with regard to follow-up oversight and analysis, whether it ought to be something done by the Department of Corrections or maybe the Legislative Coordinating Commission or someone else, if there's a more objective follow-up to determine if the changes to the formula, if we were to implement them, if they worked as anticipated. Sometimes Senator Limmer is a bit inscrutable, so I'm asking the question directly to see if maybe I can learn a little bit more, we can learn a little bit more about the chairman's thoughts on that question in particular.
Chair Limmer.
Thank you, Mr. Chairman. I was waiting for my turn to discuss some of these issues today. When it comes to the, you bring up specifically the probation reform issues, I'm wholly in support of giving the counties the money that has been promised by this legislature many years ago. That was the very premise of our version of our bill, a full 50% of their costs. I am concerned about a task force that would be moving in the direction, and strangely, we haven't really heard this from any of the testifiers, this concept of a statewide supervisory standards. I'm always concerned about centralized government. I'm always concerned and hopeful that local decision makers can make good decisions on their own, provided they have the adequate resources. We haven't given them adequate resources. And quite honestly, I've met a number of them this year, probably more so than ever before, and I'm very confident in the professionalism that they've brought, the conversations they've brought. I hope that they aren't falling into this concept that, oh, we can be a part of a statewide supervisory standard that may eventually turn into conditions, their policy conditions that might be governed from on high somewhere. And then if they want to go forward with a more stricter probationary policy and a centralized authority says no, and if you don't do it, you're not going to get the funds, I'm concerned about that. And I don't think that's been really worked out yet. So, but from the funding standpoint, I love the idea of giving money to these people that have a difficult job We haven't given them the resources that they want or have wanted in the past. Let's see what they can do with it. I think they're up to the task. And less bureaucracy, I think, is better. If someone can convince me that more bureaucracy is better, I'll listen. I may not be convinced, but that's the rub when it comes to where we're going. What direction are we going into? And I have other questions to ask other people, but do you have any further questions, Senator?
Yeah, and I will certainly call on you, Chair Limmer, once Senator Latz is done. But Senator Latz, to your question, I think it's a fair concern that the chair shares here. I think it's important to talk it through. What I'd like to know is of whether Ms. Stark can come forward and speak a little bit about this issue, about the centralized, the concern, over a centralized one spot, that will, quote unquote dictate, if you will, to counties. And I see Jason Anderson is also coming forward. So perhaps if you could just share, your thoughts as folks out in the field. I would imagine there would be some concern, in each of the counties, because we're such a big, if nothing else, because we're a big, diverse state, and there's lots of different resources and, geographic, cultural, dynamics, et cetera. But I'll stop and let you dive in a bit.
Thank you, Thank you, Mr. Chair, members of the committee. I know different people keep coming up with me. We have a lot of probation experts in the room, so I often phone a friend because I know a lot about this issue, but they know more. I will say the general county position on the Supervision Standards Committee is that we do support it because there is a minimum level of standards that we think all probation departments should have. And it all aligns with evidence-based practices, which is what we are already doing, but we want to make sure that there's some consistency. For example, with risk assessments, we want to make sure that if someone is high risk in one county, that the risk assessment says that same person in another county would also be high risk, so that they get that intense level of services to make sure that they don't commit another crime. Because, we talk about rehabilitation a lot, and that is directly tied to protecting victims and making sure other offenses don't happen. And I think, so Tammy Jo Lieberg is the Candy Ojai County Director, and Jason Anderson is also here. So they can talk about what they had envisioned when we've talked about supervision standards when we created this proposal.
I saw you flipping a coin. It looks like Jason won that one.
If I may, Mr. Chair, thank you. And whenever there's a television screen or a microphone, I'm going to be here until someone says get away. It's my ego. I apologize. So this whole issue of the reform and a new policy or a new process, I'm not a politician, but I can appreciate that people are rarely as upset with a final product as they are maybe concerned or frustrated about the process. How do we get there? What does that look like? I think Carly did a nice job of teeing this up about our desire across the delivery systems to ensure that there are some base level expectations of what supervision looks like. I've had the pleasure of working in two different delivery systems in my career. I worked for the Department of Corrections as a probation agent for a little over a decade, and I now have worked in the county system for about the same span of time. And while I appreciate, because I work within a county system, I appreciate the autonomy I have. I appreciate the fact that I can be nimble and I can adjust and pivot and do what makes sense for Itasca County. That's awesome. I also have experienced across the state vast inconsistencies of what supervision might look like. Now, I don't want to say that in an unkind way, like, boy, there's places where it's really 1962 still. But there are some places, there are some counties that aren't doing the evidence-based practices at a base level that maybe they ought to be. So if we're looking at raising all ships equally and funding-wise, I think it's reasonable that we be at a base level of what supervision looks like. not drill down and micromanage. I'm concerned about overreach and bureaucracy and centralized government as well, Chair Limmer. I share that concern. And maybe I'm just cautious, maybe I'm just optimistic that I don't envision that this supervision standards work group is an attempt to accomplish that. I think it's just to make sure we're doing some baseline evidence-based practices. So, thank you.
Okay. Please.
Chair, committee members, my name is Tammy Jo Lieberg. I'm the director at Candy Ojai Community Corrections, and I'm also a co-chair for MACAC and president-elect at MACAC right now. I also share a little bit different than Jason's viewpoint in terms of the fact that I have 30 years of corrections experience, all of which have been in a Community Corrections Act county. Not the one I'm in now, but in 2 different counties. I very strongly do believe that it is directly needs to be the county's choice. And that's one of those, that's the beauty of where we're at today, is the fact that we have an agreement between county probation offices, community corrections probation offices, and DOC. Something we've never seen before. But that part of that is that choice, allowing that choice to be at that community-based level. And so I wanted to make sure that we had that clear, that this is a county-driven initiative that allows for us to maintain those choices.
Chair Limmer, and by the way, Senator Ladd still has the floor. We're on this particular issue, but unless you're done with it, sir.
Boy, always reluctant to say I'm done and give up the floor, but I don't want to interfere with the conversation because it's fleshing out basically what I wanted to learn. So
I think there's wisdom there. Chair Limmer.
I'm having a really good thought process here. We have probation officers saying they want basically uniformity in risk assessment, and yet we just heard Senator Latz talk about the independent nature of prosecutors in separate counties prosecuting or deciding not to prosecute criminal cases. So am I wrong in that? We're having the argument that certain officials can make their own decisions regardless of the uniformity standard. But now we're talking about a uniformity standard to justify a central supervisory board. Heavy on the word supervisory.
If I may, Mr. Chair. Well, I'm not going to weigh in on the prosecution issue because we are probation professionals. However, I will say I do see a bit of a difference in the Supervision Standards Committee based on what I've had conversations with you about. So right now, the DOC actually has broad authority to impose supervision standards. They could be doing a lot of this work already and having counties, directing counties to do this. The process we are creating is a collaborative way to have the counties be involved in setting those standards. And we've got that, we would have that base level, which, as Jason mentioned, not all counties are there, partly due to being under-resourced. So they want to do evidence-based practices, they want to do all the good things, but they haven't had the money. So we want to bring them up there, and then counties would be able to add from their budget to do some of those individual things for their community, those innovative services that we know counties can do. But the Supervision Standards Committee, again, this actually allows more county input in shaping what they can do, because I don't think that there are lots of DOC committees right now where counties participate, but this would be one where counties help define the way the committee works and how their input is received by the Commissioner of Corrections.
Chair Limmer.
You know, we've been following the judgment of some of our commissions lately. Some of the direction in our criminal justice system. Some of their decisions are being made independent of the legislature. And some of them have the effect of law, unless the legislature repeals those decisions. I am concerned about commissions and boards that would have that same effect. If there was a certain administration that didn't want to rely on probation as the mainstay of our criminal justice response to criminal behavior, and that's what we do in Minnesota. We try not to rely on incarceration, which is, I think, a good philosophy. I think there's some that want to now reduce the probationary role in the same way, and move it down so probation becomes even less. And we've seen different efforts to do that over recent years. So are we going to get to a point sometime where we'll remain the second lowest incarceration state in the country? And maybe just for parity, we'll lower probation down to the second lowest probationary level in the country as well. I believe that you should have some standard maybe standard isn't the right word. I think you need to have proper response, proportional response to the crime that has been found guilty, has been convicted, and I think we're moving in a direction. I'm suspicious that a supervisory board could begin to have that same authority and move probation in a less dramatic way. And quite honestly, I think the best decision is in the hands of you all in your local area. I think the risk factor, studying the risk factor, is a question that I would like to ask is the risk factor of a felon who's on probation coming from a community where it's a very high level of crime, perhaps a high level in that particular person's neighborhood. Their family is got a long history of criminal activity versus the same person or a different person who's been convicted of the same crime, but when he goes back to probation, he doesn't have that environment to go back to in a rural environment. Now, should uniformity dominate that decision for both of those individuals, or is it a different factor? I don't know. That's why we have probation officers. That's why we have judges that impose those types of things. But I think there's a lot of questions to be asked. I think there's philosophies of our state criminal justice system, our correction system, that needs to be vetted a little bit more for us to understand what's the path in the future. I thought the Senate version that we passed satisfied a major factor by giving 50% of your costs to you. And because I've heard you come up here all the time, please give us something more. We're having a hard time. Our caseloads are overwhelming. We can't satisfy. We don't get enough visits with the charges that we have. And now we're giving you that opportunity. I'd love to see you take it and use it and, go crazy with it. But now I'm hearing that you want a level of bureaucracy over you. And that rarely happens. So try and sell me more, but I'm not buying yet.
So, Chair Limmer, I'm not unsympathetic to your views about making sure that our systems are flexible and, quite frankly, autonomous enough to be able to apply strong flexibility. Obviously, there's evidence-based practices that I think good professionals want to make sure that they're pursuing in that. It does seem to me that what the counties are proposing actually align with your desires. I think that under the status quo, arguably what you have is a real strong hand at the Department of Corrections. I think it's a testament to this department that it doesn't, attempt to have a heavy hand here, and in fact have been quite encouraging of the counties to come together, to make the space for the kind of really smart decision-making that I think that you want, and frankly, I want as well. I think that, and testifiers can certainly either reject my analysis of that or you know, add to it, but I do think, you know, again, from the House position, you know, there's a lot of money that we want to be able to put on the table because it's needed. The time for accountability is when you make those appropriations. That's how I legislate. That's how I encourage the House to legislate. I would hope most of us would do that. We heard earlier from the county commissioner that we have a failed formula. It doesn't meet the needs of what we need to do and you know, how our society is evolving and changing and moving and all the knowledge that we're acquiring. So I don't know why we want to make a fight out of that, you know, desire on the part of our delivery system to be able to have a formula that actually works for them. I think really at the end, that's really the big issue on the table. The unfortunate thing, right, because we've not done what we should be doing on this side, is that, you know, it's kind of like a terrible thing, you know, for the counties. It's like, you know, don't do any change because I don't want you to, you know, whether it's me, the chair, you know, or do the changes I want you to do, you know, because I've heard that criticism. It's fair. And we won't change the formula, but we will give you a lot of money to try to catch up. Boy, if I were the counties, I would say, you know, if that's the best you can do, then maybe that's what I got to do. But then we're missing just this incredible opportunity in our state to get powerfully aligned with our counties, with the state as a true partner, and precisely not, you know, depend heavily on the department to be the sole, if you will, arbiter of what that partnership could look like. And so I think there's a great opportunity before us, and I would certainly encourage us to seize it. And I do appreciate, you know, slowing down to be able to have, you know, this exploration. Mr. Anderson.
Thank you, Mr. Chair. These are great points. This is why we're here. This is the work, right? This is the work. We've had a lot of conversations about the hypotheticals. How could this buff out? What if we get the money but no policy? Is that a win? Is that a loss? Is that a we can live with it? It wouldn't be a loss. I'm not going to lie. It wouldn't be a loss. And yet, is you know the current formulas and the current mechanisms are what got us here. That's what got us here. And I won't go back to the numbers and talk about how many years it's been since you've been beaten to death with that. I really appreciate the concern about the added layer of bureaucracy and what can happen of that. And I would trust that you would believe me when I say we didn't sit down and say, you know what we should do is come up with another layer of bureaucracy. It was really, you know, if we're going to come up with an idea, a model to create a new funding formula, we ought to maybe make sure that we've shored up to ensure that we are at a certain base level of service. And that's really where that came from. It wasn't, this is an opportunity to really do some centralization and create all of one. None of us want all one. We're really unique here. We have these 3 different delivery systems. And believe me, nobody sat down someday and said, you know what a great idea is for probation in a state is to have 3 different delivery systems where they're funded with these different, no, it happened over the course of time, right? But here we are, and it does create some really neat stuff where agencies that have, you know, different services available and different tax bases are able to innovate and do and grow, and we learn from them, and we adopt, and we grab stuff, and we do. And it's a fantastic model. We're walking this tightrope, trying to say the right things that appease people who are looking at it from this angle and appease the people who are looking at it from very different angles. So I hope you can appreciate the balancing act that we're accomplishing here. At the end of the day, everyone in this room wants the same thing. We all want a safer Minnesota. We want people held accountable who ought to be. People get the help who need the help. Fewer victims. We're just trying to marshal the right resources to do that this year, next year, and 26 years from now. So we don't look back and go, it's been 26 years since we've been fully funded. We don't want to have to say that again. So however many chefs need to be in the kitchen to cook that recipe, let's go.
Refreshing honesty. I appreciate that.
Mr. Chairman.
Chair Limmer, and I know Senator Bingham wants to weigh in on this.
Yeah, and I haven't even gotten to my questions that I wanted to ask
Indeed.
of those prosecutors over there. I don't mind you making a formula. I think a formula is good. The question is, who controls the formula? Give us some ideas of what a formula is, and upon agreement, we'll write them into our statute books. Can you live with that?
Let's go, Mr. Chair.
So, and I don't know how do you do it, I don't know the timing of it, but it'll take a while for the money to get to you anyway. But I think we need your direction and advice of what that formula should be. That's what I would propose.
It sounds like you had some other issues.
And I do have other questions, so. Did you want to make a quick comment, and then I can get on with some
Yeah,
other
and
questions?
I know Senator Bingham's looking at it, but Senator Lutz does have the floor, and unless you want to, you want your colleague to weigh in on this particular issue or not.
Mr. Chair,
Senator
just
Bingham.
directly to that.
Senator Bingham.
That's exactly what I just said like an hour ago. Senator Latz, was we have the money, let the group come together. We can make it even temporarily for them to finalize and make permanent the recommended changes due to severity, due to caseloads, and that's weighted equally. I simply put, this is the right thing to do, is to put a temporary single funding formula for all three disciplines, and then on another equally temporary basis, put together a working group. I don't care where it's housed, just do it where the stakeholders who have put hours, months of work into this can bring it back to the legislature to make it permanent. That's exactly what we need to do. And so I hope that's the agreement with the money out of the Senate.
Chair Limmer.
Mr. Chairman, I was thinking that someone in the profession could give us an idea what a formula would be best, how it would be best envisioned. They're full-time employees, Senator Bingham. I don't know if we need a task force and all of that. I think we just need advice, direction. Bring it to the legislature, and we'll consider it. And then, as legislators, we'll all have our hands in testing it and proving it. I think, and in the meantime, temporary funding formulas, just like anything else temporary, like taxes, never seem to go away in this state. So I would rather trust the counties with the checks that we can give them, and by next legislative session, address this issue with a true formula. I'm thinking out of my top of my head right now, but
I don't know if I'm.
do you have a reaction to that?
Ms. Stark, I have an answer, but the question is to you all.
Mr. Chair, Chair Limmer, I have many reactions to that. My first is that I think that's what we were intending to do with the proposal that we brought this year, which puts in that temporary formula to give us enough time to do the workload study, which really gives us a sense of how much probation costs and takes the same people, these professionals, and puts them on that group to help run the workload study, because in the past, the Department of Corrections has done caseload workload studies, and what I've heard from counties is that it didn't quite work well. And I wasn't around then, so sorry, DOC. I don't know anything about it. We just know that we have the right people involved in this work, and temporary place to get to a new formula with a workload study is kind of what we thought might be a good plan, because that formula for next year, after the workload study, we would have to bring it to the legislature because we did not want to cut out the legislature at all. So that is my opinion on it, and I think that there are some tweaks we can make from the full proposal that we have in the House bill, and from not doing any work on the formula this year. I think there are places in the middle that'll still help counties move forward and create more equity between counties and the DOC and help public safety in Minnesota.
Good. Charlie?
I appreciate your comments. I don't think we're going to make that decision in the next 20 minutes. We have a couple days, and I'm sure this issue isn't going to go away today, and so let's keep talking. Okay. Mr. Chairman, I had a few other questions, but I believe Senator Latz had the floor. Is that correct?
No.
I have the floor?
He actually gave it up. This will go down in history on the book somewhere. Senator Latz actually gave up the floor. So.
Well,
Chair Limmer. Chair Limmer.
How dare you give up the floor to Senator Latz? Mr. Chair, I have other questions. I know that Senator Osmick wanted to ask questions too. I think while I still have the microphone, I'm going to ask my questions. I'm not sure if I'm going to get it back. County attorneys, I have a question for you. Someone could come up.
Come on up. Come on up, county attorneys.
Come on down.
Come on down. I remember that show. Judge Small.
Thank you for coming back.
Sure.
There was a reference to a competency bill. Are you in favor of that competency bill? And I know of two competency bills, so which one are you talking about?
Judge Small.
Mr. Chair, there have been a lot of discussions about the competency restoration bill. The latest version that we worked so hard with all the stakeholders, the number is escaping me right now, but it's the one that we most recently worked on with NAMI and the public defenders and the like.
Mr. Chair, I'm aware of what it is. The other bill is a much smaller abbreviated competency bill. It goes into a few stray areas of Senator Abler's. That one is not what we're talking about. We're talking of the more global, well, maybe not global would be the word, more expansive reference. And we in the Senate have not had a hearing in our Judiciary Committee on it. I know it's a very complicated area, so I was told, scuttlebutt around here, that the stakeholders are not in agreement on that bill, or has that changed?
Judge Small.
I need to call a friend, Your Honor.
There you go. Good to see you, Ms. Haas.
Good morning, everyone. Nancy Haas with Messerly and Kramer here on behalf of the Minnesota County Attorneys Association. The County Attorneys Association has worked very hard with all the stakeholders, and we support the bill, House File 2725, that passed the House and is now over in the Senate. And so it is comprehensive. It sets up forensic navigators, and it sets up a court process to handle those in Rule 20 cases.
Mr. Chairman.
Chairman.
The question I asked is, are all the stakeholders in agreement to the version that is now before us?
Ms. Haas.
Yes, Mr. Chair.
And has there been any, thank you, Mr. Chairman, has there been any participation by our law enforcement community on it, and are they in favor of this bill?
Ms. Haas.
Mr. Chair, I believe law enforcement was a part of the task force that put the draft legislation together. You would have to ask them if they have reviewed the most recent bill that passed off the House floor.
Chair Limmer.
All right. I don't know if, I don't see any, well, might be one or two, but it might be unfair for me to ask them if they have a position on a bill that the Senate hasn't heard. But we can give it a whirl, but I haven't gotten any comment from law enforcement. Matter of fact, there's been some sidebar conversations that there are a few unanswered questions or concerns.
Ms. Haas.
Mr. Chair, in the work with the County Attorneys Association, when we take lead on legislative language, we often hear from our law enforcement partners if they don't like what we're doing.
Chair Limmer. Good luck with that one.
This is like a ping pong game. Well, again, the Senate has not had any, at least our Judiciary Committee has not had any hearings on it. So I don't know where we're going to go unless we have a full-scale hearing on it because it's a complex area. So I think Senator Latz agrees with me. Oh, a full-scale hearing, okay.
Yeah, you do have the gavel tomorrow.
Well, moving right along, I have some other questions. The issue of the AG's supplementary budget request. I'm questioning whether the Senate Judiciary Committee has jurisdiction. Now, granted, there's a few things in the House bill that I would question whether, how it crossed over that jurisdictional line. But usually that, at least in the Senate, that's a state government committee. And I don't know the story of why it wasn't included in the state government budget. And so that's another area of concern I have. Can you tell me how we got to this point?
And
Or is it purely a House action?
No, I think it's important to hear from our folks, but I can share that, as chair of the committee, when I was approached on it, I had a similar immediate reaction. Of course, you know that, all committees wind up working policy and appropriations of accounts and departments that are not in our direct supervision, but we do so because the issues at hand are clearly within, our responsibilities. And so being able to effectively respond to the needs of prosecutors across the state to maintain public safety seemed like a very appropriate request of the Public Safety Criminal Justice Reform Committee. I've got other accounts here. We've got, highway monies here. We've got the back and forth, overlap of state patrol with trunk highway. I mean, I'm constantly having these conversations with Chair Hornstein about what the appropriate focus is. So I'm just sharing you my thought in terms of my level of comfort and appropriateness with this. But I'll certainly ask Judge Small and or his colleagues to comment as well.
Mr. Chair, Senator Limmer, the County Attorneys Association is willing and wants to be as great assistance as we can to the legislature. And so if testimony is requested from our association, we are there. And we try to provide the best information to legislators that they ask us about. And state government did ask us, and we were there. The House asked us, and we were there, and that's what we try to do. So that's the best I can answer your question, Senator. If someone, committee asks, the County Attorneys Association is going to be there.
All right. Sure, Limmer. One other question, and that's regarding the transparency of decisions made by county prosecutors. Senator Latz had a good conversation about it. We make rules for all sorts of things. We even make rules for private business. We deal with, we write bank rules. We put standards for many different professions, and licensed professions, banks, the use of data that private sectors collect, all sorts of things. But I would think that an elected position justifies a transparency, probably more so than one that's not elected. And I haven't quite bought into the idea that simply because it's complex, that we should negate transparency. And, you know, maybe there's a better way for county attorneys to explain, and maybe we can educate the public at the same time. But quite honestly, I think the public, I know the public is asking questions. They're asking questions primarily in two jurisdictions of why there's almost a wholesale approach, a reaction to not prosecuting criminals. And almost a braggadocious approach by some that claim that, well, if the legislature doesn't make reforms, I will. Well, I look at county prosecutors as administrators of criminal prosecution. And the rule book that they play by, or that they work within, are the parameters that the legislature has established in law. We give them jurisdiction, but I believe, like Representative Johnson, that jurisdiction should be applied in a case-by-case basis and not a wholesale chapter and verse. And so the public is beginning to question that too. I think there's justification for requiring prosecutors to explain. And it doesn't have to be a big explanation. If there's not enough evidence, you can say not enough evidence given to us by law enforcement. We can't do it. Dismissed. But quite honestly, I think there needs to be some kind of public record, and it's been justified by the actions in the last few years. So I hope we can come to some terms on it. No question.
Well, and Chair Limmer, again, I am not unsympathetic to that transparency desire. I may have other reasons for you know, what that motivates me in terms of, you know, wanting to know, you know, why decisions are being made. But the point is that we can have a common ground of wanting to have access to good, objective data and collect it in such a way that, you know, doesn't, you know, tip, you know, the scale, if you will, one way or the other, but really just objectively lays out for us the ability to have the smart collection of data that allows for objective, good analysis. And quite frankly, that could be helpful for people like you and me, not just, you know, the general public, about what's happening, you know, with their local, you know, prosecutors. But in addition to that, that can powerfully inform people like you and I, you know, relative to policy frames that perhaps we're just not, you know, fully aware of because we're not the ones in the field and, you know, interacting constantly with the complexity of decisions that go into, no doubt, the discretion that we properly allow. So I hope that we do find a common ground. I think the House offers a way for us to get that without prejudice, one way or the other. And my hope is that, you know, we can have a fruitful, you know, acceptance and shaping of that particular proposal. Judge Small, any last thoughts, comments, advice?
Mr. Chair, Senator Limmer, I appreciate your concern. I do not think for one moment that prosecutors are shirking transparency at all. To directly respond to your question as it relates to the bill, there is a public record of all dismissals. So there is no question but that dismissals are public. Thank you.
Very well, thank you, Judge Small and Mr. Metz and Ms. Lorsberg. Yes, Chair Limmer.
Question to Judge Small. In that, is that information in the form of a publicly accessible website that recognizes the attorney office that makes that decision by name?
Yes. I'm sorry. Mr. Chair, is there a public, let me make sure I understand your question. Is there a record of the dismissal by the county that made it or the individual assistant that made it? I'm trying to remember all the fields in Minces, and my best answer would be, Mr. Chair, is that it's all public. That is to say, in Minces, the publicly available information would have the case number, it would have the complaint, so you would be able to see the assistant county attorney that signed off on the complaint and the county attorney who authorized the dismissal. That would be of public record. Maybe Representative Becker-Finn might have better recent knowledge of what's in Minces.
To committee members, we're at 11:55, which is 5 minutes before we're scheduled to adjourn. I am not going to adjourn this conference committee without taking action, any action, to continue building our bill. It sure looks like we're going to have to take a recess in order to do that. And so I will be doing that because, I did share 11 provisions, just so everyone knows. I shared 11 provisions with the Senate beginning late last night. Early this morning, our staff has been working incredibly hard to be able to put together, those areas, identify, put together, a list of those areas where, reasonable people should be able to move. And I know that, Chair Limmer and I had some brief discussions about that, not about the details of those, but just maybe very, open about, let's get moving on this. My hope was that before noon, we would at least take action on one of those provisions, which is actually a Senate provision. We really like it. We think that, doxing, protections against doxing for prosecutors, judges, public defenders, defense attorneys, and correctional employees, extending the current law to those public servants is an absolutely appropriate thing to do, and we agree with the Senate's desire to do that and how they want to do that. And, there are a number of these provisions that run through both of these bills. There's just absolutely no reason why we should not be moving forward with them. So it is my intention that we do that today. But we're 2 minutes away from when we're supposed to adjourn. So, Mr. Chair, I'm going to call us into recess and until further notice by the chair. Hopefully you and I can have some really good, honest conversations about, okay, so how do we do this, when we come back, so we can be really efficient and respectful of everyone's time here, as we were earlier with Senator Osbeck. Thank you, Judge Small, and your colleagues. I've got a minute and a half, Chair Becker-Finn.
Yep, this will be real quick. Thank you, Mr. Chair. I just want to, on that last point, I just want to point out that actually one of our identical provisions in making court documents public through the microsystem long-term, we can actually find all that information and it makes it public in a real way. So I just wanted to lift that up as one of the things where we're totally lined up and actually gets us to a transparency piece that I think we all care about. Thank you, Mr. Chair.
Thank you.
Mr. Chairman?
I'm here, Senator Lance.
I got Mensis up on my computer. Anyone wants to see the fields and the MCRO, anyone wants to see the fields, you can come look. It's got all the attorneys of record, what was charged, what was convicted, what was dismissed, the date of the offense, the statutes under which it was charged, all the terms and conditions of the sentence. And similarly, there's a separate sentencing documents are also public. I don't have any special access to any of this stuff. It's available on the public internet. I just know how to find it, which is very simple on the court's website.
Very well, members. We're going to see, hopefully this afternoon, whether this conference committee is really serious about building a bill here. You know, yes, we're going to be looking for good availability times. Chair Limmer, are there any potential issues with your agenda and the agenda of your colleagues?
I'm sorry, could you ask?
I'm asking about if there's any impediments for us to come back once I go to recess today.
Mr. Chair, I know session has already begun. We're an hour into it. And I don't know if we're still in caucus meeting or not. We are. And so pending the serious nature of whatever we're going to talk about in the chamber, I guess we're at that mercy of them. But other than that, I don't see anything else.
Senator Osberg?
Mr. Chair, I would only say one thing. I will gently disagree about using the word serious when you're describing whether the Senate is serious about having a conference committee report or continuing. I certainly believe we are. So I wouldn't characterize in your comments that we're not serious on the Senate side. That's all I'll say.
Noted, Senator Osbeck, and I chose my words very carefully. I didn't identify the Senate, I identified this conference committee's seriousness. So this is on us. And so we're public, we're in front of everyone in the state of Minnesota, you know, and so I'm just laying it out there. You know, we're either going to get this work done or we're not. I will be here. My conferees will be here. The only question is whether the Senate conferees are going to be here, because I can't decide that for you. But I know my colleagues, I know myself, I know the responsibility that I have to get this done. We're talking about the public safety of the people of the state of Minnesota. Prove me wrong and overly concerned by coming back today to take these votes. That's all I'm asking. That's all the public is asking. I'm not a game player. I hate it. Thank God next year I'm not going to be here, you know. But I do believe in the seriousness of our work. That's what's before us right now. It's either we decide or someone else is going to make these decisions. But they will be decided. So members, with that, Chair Limmer, please.
Mr. Chairman, the Senate members have every desire to negotiate the best possible bill for the people of Minnesota. We'll do as much as we can to accomplish that goal. Thank you.
Thank you, Chair Limmer. Let's hope that as much as we can means we get it done. With that, members, this committee stands in recess.